Committee will come to order. Sorry, we're a little behind in getting started. Some 9:30 committees ran a little close to 10:30. So anyway, our first order of business today is we have kind of a personal point of privilege from Senator Bowers.
Thank you, Madam Chair. I have 2 pages today from Russell County. So girls, could you stand up? There they are. So we have Hadley Brown and Journey Winsful, and they are our only Senate pages today. So we'll see them later on the floor. So thank you for coming up from Russell, girls.
Thank you for coming here today, ladies, and being at the Capitol and for joining us at Senate Judiciary Committee. Appreciate that. And you'll maybe have some work to do on the Senate floor this afternoon if you're only pages. And with that, then, committee, we will open the hearing on Senate Bill 292 and hear a bill brief from the reviser.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Reviser of Statutes. You should have in your packet a slightly longer than normal bill brief for Senate Bill 292. Not as long as the next one, or maybe actually this is the long one and the next one's the shorter one, but they're both pretty long today. Senate Bill 292 updates statutes related to the Kansas Army and Air National Guard, provides for the appointment of a state judge advocate, and provides for the adjustment of death and disability benefits. So I'll hit the highlights here briefly. Like I said, there's more detail in the bill brief and in the bill itself, and you've got some experts behind me that are going to get into the details a lot more than I would like to. So new section 1 provides for the Adjutant General, with the approval of the governor, to appoint an officer as state judge advocate. It also provides for appointing as many assistants to the state judge advocate as they deem necessary, and they will be assistant state judge advocates. All of those appointees have to meet the definition of judge advocate that's provided in KSA 48-2101, and I provided that definition there in the second paragraph, third paragraph of the brief. That means an officer of the Judge Advocate General's Corps of the Army or the Navy or of the State Military Forces, an officer of the Air Force or the Marine Corps who is designated as a judge advocate, or an officer of the Coast Guard who is designated as a law specialist. So those folks would be eligible for appointment to these positions, and assuming they meet the other criteria as well, but that's the base criteria. New section 2 deals with benefit amounts, specifically those provided in KSA 48-267 and 48-269, and those are in the bill, sections 16 and 17. So this is some of the big meat of the bill here, is dealing with these benefit amounts. And new section 2 provides that those amounts can be adjusted by the Military Disability Board, which is also provided for in KSA 48-261, that's section 15 of the bill. And the bill provides that commences on July 1st of 2024, and each July 1st thereafter, they can adjust that percentage equal to the percentage from the previous calendar year based off the Consumer Price Index. So this board will be able to adjust the amount. And I'll note, and hopefully they can correct me if I'm wrong, if you do work this bill, the bill before was from 2023 and this date was 2024. So I presume they'll want this date to be 2025, so that the new rate will be for 2024, July 1st, 2024. And then on July 1st of 2025, they would adjust the rate based on the CPI. So if I'm incorrect about that, they can let me know, but that would be a date update you need to do if you work the bill. There are a couple others, technical date updates that I would recommend you do as well, but this one was more substantive potentially. Section 3 then gets into the statutes that are updated throughout this code. I won't go into detail on any of these. At this point, you can see them kind of outlined in the bill. The ones I wanted to focus on were the ones I just talked about, which are section 15, KSA 48-261. The note about it on the bill brief is near the bottom of page 3. But this is the statute that relates to death and disability benefits that we were just talking about. It also creates that Military Disability Board that I was just mentioning. and provides that they determine the percentage of total disability and they determine the award compensation for disability or death in accordance with the provisions of the sections around it, 48261 through 48271. The bill is adding some language that specifies that the board shall meet at least annually and that members of the board will receive compensation and permitted allowances in accordance with KSA 75-3201. So those are two new provisions about the board, and that board is important under new section 2, so I wanted to highlight that for you. Then section 16 is another major change here, and that's the one that defines the monthly benefit for the members who are entitled to benefits for a permanent disability. Again, this is the rate that's adjusted under section 2. The base amount is provided here, and it increases that rate from the current law, 120 plus 12.5%, to 850 plus 12.5%. So there's some adjustment there and an increase in the number, and that's one of the big things that's changed in the bill. And then the last thing I'll point out, I think, is substantively is section 17. That's the amendment to 48269. That's the death benefit provided. And again, this is a rate that can be adjusted under section 2, and it increases the monetary amount under that section as well. So I just wanted to highlight where those are and what those are doing. And then I'll point out a technical thing that I'll try to mention anytime it's relevant. You'll note in the bill title and in section 21, there are some extra sections that are not amended. They're just repealed. And so I highlighted those at the end of the bill brief. There are a handful of sections that are just outright repealed and will be removed from the law. So I always want to bring that to your attention. Be happy to answer questions.
Thank you. Committee, any questions? So just as an overall summary, the bill relates primarily to benefits for National Guard service members. So I have that correct?
Madam Chair, I would say, yeah, the big picture, the two things, the two things I would say it does is, one, it updates all of the statutes essentially related to the Army and Air National Guard. So that's a big chunk of it, is just going through and updating language and making adjustments for various reasons that I'll let the proponents explain. And then part 2 of the bill is really about the adjustment of death and disability benefits, increasing those amounts and providing that they can be adjusted by the board that already exists in our current law. So it's really those two big picture things.
Thank you for the big picture and for the thorough details that you provided as well. Seeing no questions, then we will invite, I'm sorry, a question from Senator Gossage.
Thank you so much, Jason. The interesting thing to me is, I understand that it hasn't been updated for a long while. We're seeing some jumps from $77 to $400 and some dollars on some of these. Is there no fiscal note on this, or who pays for that?
Madam Chair and Senator, I don't know if you have a fiscal note in your packet. I don't see one in here. I'm sure there is one. And hopefully the Adjutant General or the Guard was asked to provide one, and so maybe they can speak to the fiscal note. But
Thank you. Thank you, Madam Chair.
Thank you. With that, then, we'll invite our proponent conferee, Colonel Jared Magg, the State Staff Judge Advocate, Adjutant General's Department. Please introduce yourself and welcome to committee, sir. And if you'll turn on your microphone and start over so we can make sure we're complete. Thank you.
Madam Chair and members of the committee, thank you very much for allowing me to appear on behalf of the Adjutant General and the men and women of the Kansas Army and Air National Guard. My name is Jared Magg. I'm a colonel. I'm also the State Staff Judge Advocate and the Senior Legal Advisor for the state of Kansas. Let me start by saying that both House Bill 2392 and Senate Bill 292 really does focus on the needed updates in the language of the statute.
And we're just talking about 292 for now, and we'll get to the other one. Thank you.
So to sort of circle back to the question before, it does really focus on, in large part, amending some very, very outdated language throughout the statutes. I do want to make one correction. The Disability Board does exist. This statute does not create a disability board. The Disability Board has been in existence for some time, and it really just covers the financial issues that we've talked about within the bill to increase those numbers to keep pace with the current environment and making sure that any service member who is suffers injury or death, that the families are properly taken care of with the amount of money that we believe covers that. As to the fiscal side of this, this comes from the state disaster funds. We did send a fiscal note last year in February of 23. So the fiscal note, it may or may not be in the record, but the funding from that does come from the state disaster funds. To be clear, again, the changes in these laws are designed to really cover issues that have been on the books for years and that have simply become outdated. It really allows us to keep pace with our sibling states and the language that they have in their statutes as well. Most states will model a large part of their military code through a model code that most states review. So the language here really is in large part amending to make it more current and at the same time allowing for some of the very antiquated language to be removed and allowing the commanders to have a better understanding of what these statutes are designed to do. But at the end of the day, these are not wholesale changes in Chapter 48. This really is a means to get us into more modern language and to keep a pace with our sibling states and the federal government. I would stand for any questions I hope to answer the questions that you had that were raised before.
Thank you. I appreciate that, Colonel. And I do have a question. Section 1 would create a new position, and it would be state judge advocate. So if you could tell us a little bit about the necessity for that and what the state judge advocate would do that the adjutant general doesn't.
So the state's judge advocate position, this really is taken from another provision. This was really movement of language from another part of the statutes, putting it really into the more administrative sides. The statutes have always allowed for staff judge advocates. They, in fact, refer to it as the judge advocate general for the state of Kansas, but we have modernized that language more appropriately. So the position has always existed. The state staff judge advocate, like myself, is generally the senior ranking legal advisor for the military. It holds a rank of colonel. And so below those positions, you have, I also am, to make it a little more clear, dual-hatted. So I'm the state staff judge advocate, but I'm also the staff judge advocate for the Air Guard. My counterpart, Jim Seward, Colonel Seward, is the colonel that is the Army staff judge advocate. And below those positions, you have numerous staff judge advocates from the rank of lieutenant colonel all the way down to lieutenant. And those are then assigned out to various units. So, for example, both the 190th Air Refueling Wing and the 184th Wing each have a staff judge advocate in the rank of lieutenant colonel to advise the commanders at each of those wings. That's uniform for the military as well, from 35th Infantry Division to the 2nd to the 130th. All of those have judge advocates assigned, so the commanders have legal advisors attached to them. We have a full staff of lawyers that serve on a daily basis that advise the adjutant general on all legal matters, personnel matters, primarily fiscal matters. But individually, the state staff judge advocate is really just the senior ranking judge advocate that reports to the adjutant general and the assistant adjutant generals.
Thank you. Committee, other questions? Yes, Senator Bowers.
Thank you, Madam Chair. Good morning, Colonel.
Good morning.
Just a quick question. I was looking at the bill brief on Section 18, where it is saying, directs the Kansas Military Board to provide armories for the use of Kansas Army and Air National Guard to strike a provision requiring such armories to be open for meetings. Does that mean our local folks at home would still be able to use the armory, or is it right now that you're required to allow them to, or I know a lot of functions are held in Senate District 36, and I should count how many armories I actually have in my 13 counties. But I do know that our armory is used for different functions. Would this be saying they wouldn't be allowed to, or
No, that
help me
provision
understand that?
would generally remain. This language was largely to tighten up the language that you can see some of the old language about the Army veterans in the Spanish-American War. We were just simply trying to modernize the language in a way, but no, we do not anticipate any changes in the use of the armories as long as the same provisions are followed in each of the locations.
Oh, wonderful. I think that you serve a big function for our small communities to have a place to meet. So I'm glad you see that as well. So thank you very much.
No, indeed they do. We
Yes.
give many legal briefings at these locations throughout the year, and we do know how important those armories are to each of the communities.
Oh, thank you.
Thank you. Committee, other questions? Not seeing any. Thank you very much, Colonel, for your testimony.
Thank you.
Do we have any other proponent conferees or neutral conferees or opponent conferees in the committee meeting room or on WebEx? Not seeing any, then we will close the hearing on Senate Bill 292 and open the hearing on House Bill 2392, updating the Kansas Code of Military Justice relating to certain definitions, unlawful acts, and punishment requirements thereof. And with that, a bill brief from the reviser.
Thank you again, Madam Chair. Again, Jason Thompson, Office of Reviser of Statutes. You have House Bill 2392 bill brief as well. This one updates the Code of Military Justice, KCMJ, as it's referred to throughout the brief and commonly known. Some definitions, unlawful acts, punishment requirements, just a whole lot of updates related to those items. And then some new sections of law and updates that conform with the Uniform Code of Military Justice, the UCMJ, and modern drafting practices, both from our office and from the codes that they're drawing from. I'll kind of do what I did last time, not get too far into the details because I'm not the expert on what of this is new and what's moved around, but I did highlight all of the new sections at the beginning of the bill that are likely moved and modernized from current language, but they're all highlighted there in the new sections that are the first 34 sections of the bill. I noted that a couple of them were added or amended by the House committee, so this has been updated from the version that was offered to the House last year. I think I'll probably just not really dive into any of those 34. I'll just let you know they're all there. And there are brief explanations of each of them in the brief. And then if you see anything that raises your interest, definitely happy to answer that or let the conferees get into those. And then I'll point out that sections 35 through 101 of the bill are those amendments and updates that I was talking about. Essentially goes in and touches all the statutes in 4821, lots of places in chapter 48, beginning in article 21 all the way up to article 29, 30, 31. I think 31 might be the last one. So there's several articles in chapter 48 that are dealt with here, updated, amended. And then just like with the last bill, I will indicate to you both in the bill title and in section 101, which should actually be section 102, the numbering didn't get updated. The bill repeals a whole long list of sections. So there are a number of things that are repealed. I suspect that many of them are either duplicated elsewhere or reenacted in more modern form in one of those new sections. So we can get into that if you need to, but I just wanted to flag for you that that's what's going on with all those sections that you don't see in the bill physically, but they're repealed outright. It would take effect on July 1st of 2024. And if you do intend to work the bill, I will note there are a couple of 2023 references that would need to be updated to 2024. So I will have that ready for you if you do work the bill to get it ready to go for this session and move it along. Happy to answer questions.
Thank you. Do you know whether the amendments that were made by the House committee, do you know who suggested the amendments? Was that on behalf of the National Guard, or was that generated by House members?
Madam Chair, it was done in the House Committee on Veterans and Military, which I am back up on this year, but was not last year. So I don't actually know, and I don't see it in the supplemental note, although it's very thorough about the technical amendments and clarifying language. I am fairly certain it came from the folks behind me, and
I was going to say, I can ask the conferee.
they can let you know for sure. I'm fairly certain it came from them, and they were proponents. And then I neglected to mention this is our first House bill. So generally speaking, I will try to tell you that it did come through the House Committee on Veterans and Military Affairs. That's what it was amended. And then in the House, it passed 121-0 last February before it was sent to you. So I'm glad I got a chance to give you that information.
Thank you. Committee, any questions? All right, then we will hear from our conferee. Welcome back, Colonel, and Colonel Jared Magg, the State Staff Judge Advocate, Adjutant General's Department. Welcome back. Please introduce yourself, and again, welcome back.
Again, Madam Chair, thank you again. And again, Jared Magg, State Staff Judge Advocate for the Kansas National Guard. To answer your question directly, those changes were by our office, and we had asked that those changes be made in the current form of the bill. This bill in particular is one that really does move language around and really deals with antiquated language. This bill in particular is absolutely necessary to keep pace with the Uniform Code of Military Justice. As I'm sure the members are aware, many of our members will from time to time move into Title X status and go on active duty, which subjects them to the Uniform Code of Military Justice. Our Kansas Code of Military Justice has not been amended for quite some time, and we took great pains over the last several years to really work to get proper language onto the books that reflects modern military service. It addresses more modern types of offenses that are occurring within the military community. And at the same time, we want to be able to provide our commanders with the tools that are available to them for good order and discipline. But for purposes of what this committee is reviewing here, it really does boil down to a change in the language itself and moving several of these offenses that were duplicative of one another into single offenses that are more appropriately handled. The issue that I would point out to the committee is that we have asked that the ability to engage in court-martial proceedings are removed from the statute. Court-martial proceedings were part and still are part of the Kansas Code of Military Justice. We have rarely, if ever, used the court-martial proceeding. Court-martial proceeding brings many issues to the table. One of those issues in particular would be upon conviction, the Kansas National Guard has no facilities to house someone who is convicted of a court-martial. Those contracts would have to occur with counties or other state locations to house someone who is convicted upon court-martial. And the lack of the use of that particular provision within the Code of Military Justice we deemed to be unnecessary. Many of the offenses that would otherwise be covered under the court-martial are fully covered by civilian authorities. For example, an offense that might be subject to a court-martial would be a violent offense or some level of significant sexual battery, rape, aggravated assault. Those offenses are all covered by civilian authorities. They have the ability to process those cases much more effectively than the Kansas National Guard, prosecute those more effectively, and of course, a system that allows for imprisonment upon conviction. And to that end, we have made a decision to ask that the court-martial proceedings be removed from the statute, as we think they are wholly unnecessary in this modern time. Unless the committee has any questions, that's the basis of my statement for now.
Thank you. Committee, Any questions? No, oh, sorry, Senator Stefan.
Thank you. I was just curious, in the Uniform Code of Military Justice, how, how fungible is that with executive administration at the federal level? Do we see it change much?
You do see amendments, Senator, from time to time. For example, one of the largest amendments occurred this year. The Department of Defense has established what's called a Special Trial Counsel Unit, which is a unit of commanders and judge advocates that address the most serious offenses within the Uniform Code of Military Justice. In most instances, the commander of, say, Fort Riley, for example, the general that is the court-martial convening authority, would have the authority to what is called prefer charges on a service member. The Department of Defense in Congress has now allowed a specific unit of highly trained experts to take on the most serious offenses, typically murder, rape, aggravated assault, and some of the more serious violent offenses. So there has been a significant revision to the code in that sense. But to answer your question directly, as far as individual crimes themselves, no, you do not see a significant amount of change unless, for example, there are changes in the law coming down from the military courts. We have seen that in the past with decisions from the Court of Appeals of the Armed Forces. And there have been amendments based upon those decisions, finding certain statutes to either be unconstitutional or otherwise need to be amended.
Thank you. And without the court-martial procedure that you said is amended out of the National Guard Code of, or the Kansas Code of Military Justice, so how would a service member then in the National Guard, would they be, if they're convicted in a civil courtroom or in a criminal trial in a Kansas court, would that conviction then be used to court-martial the person, or is it used at all or considered at all by the National Guard, I guess is my question.
That's no. What happens in the military, Senator, is that we engage in what's called non-judicial punishment. These are administrative actions. You may hear the common term Article 15, and Article 15 is a punishment that a commander can execute on a particular service member for, say, failing a fitness test or testing positive for a narcotic. In the event that someone were to be convicted in a state proceeding, the military will generally move to administratively separate that service member from the National Guard based upon that civilian conviction. We can move for administrative separation parallel to those proceedings. We do not need a conviction. We do have regulations that allow for us to move forward. Practically speaking, most of our members and where most of our punishment comes from is in the non-judicial punishment administrative actions. We do demotions quite regularly for individuals who are not performing well. We do bars to re-enlistment. So most of what you see in the National Guard really is nowhere near any of the court-martial type of proceedings you would see in a court-martial, but are really designed administratively to deal with minor offenses.
Thank you. Committee, any other questions? Not seeing any. Well, thank you, Colonel, for your service as well, and to the other members you have brought here today. We thank them for their service also. So thank you for being here and for the testimony, and we appreciate you coming. Appreciate that. Thank you, sir. With that, then, do we have any other proponent, conferees, or neutral or opponents in the committee meeting room or on WebEx? Not seeing any, then we will close the hearing on House Bill 2392. And committee, we do have some time to work some bills that we have previously heard. And the first one we're going to look at is Senate Bill 379. And while you pull that up, we're going to stand at ease just a moment. committee. Hopefully everyone has had time to pull out the file on Senate Bill 379. And we worked this a week or so ago, but the revisor can give us a reminder and a bill brief about it, please.
Thank you, Madam Chair. Yes, Senate Bill 379 was the bill you heard on Monday that was brought to you by the Kansas Judicial Council. It's the probate bill, dealing with notice to creditors by publication, also dealing with transferring personal property by affidavit and small estates, and finally modifying some time requirements for notice by publication when sales at public auction are happening under the probate code.
Thank you, committee. Any questions? And if none, then I'll entertain a motion on the bill. Or I will move, yes, Senator Baumgartner. Can't speak.
Madam Chair, I move we pass out Senate Bill 379 favorably for consideration.
Thank you. Do we have a second? Second from Senator Gossage. Any discussion? Then you all have heard the motion. Those in favor signify of some discussion. Senator Steffen.
Thank you. Is this a consent calendar prospect?
Well, I was thinking about that. Sometimes, though, senators don't necessarily favor consent calendar bills, so it's up to the will of the committee. Yes, some senators, I should say, don't favor consent calendar bills.
Madam Chair, I will amend my motion that we pass it out for the consent calendar. And then if a senator chooses to pull it out of the consent consideration, then we'll go from there.
Fair enough. Then you have heard the motion. We will need to first withdraw the second on the motion, and that second is withdrawn. And we do have is it a substitute motion or a new motion? It's a new motion to move this out favorably for passage onto the consent calendar. And we have a second from Senator Gossage. You all have heard the motion, and seeing no discussion, all those in favor signify by saying aye. And those opposed, same sign. The motion carries. Thank you. And next, we will be working and final action on Senate Bill 318. And the revisor can tell us information about the bill, please.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office, Senate Bill 318 you heard on January 23rd. This is the bill about that removes the requirement that municipal courts collect fingerprints from certain folks that are convicted of violating municipal ordinance provisions related to vehicle registration or driving without a valid driver's license or motor vehicle liability insurance coverage. I think you heard that under the Kansas Code of Procedure for Municipal Courts, you're required to collect fingerprints for certain offenses, and they're asking you to remove that requirement for those municipal ordinance violations that relate to registration of vehicles or driving without a valid license or driving without motor vehicle liability coverage. So for those offenses, you would no longer have to take fingerprints in the municipal court.
Thank you. Committee, any discussion or a motion? Senator Haley, and then Senator Olson.
Thank you, Madam Chair. I certainly think this is a good measure. We heard good testimony on it. I would move the committee report, Senate Bill 318, favorably for passage to the committee of the whole.
Thank you, Senator Haley, and the second from Senator Olson. Any discussion? Senator Bowers.
Thank you, Madam Chair. This was introduced late last year, too late for us to hear it in our committee, so it came up early this year, and it was brought to me by the Kansas Municipal Judges Association, and that's who I introduced it for, and we heard from. And also we had neutral testimony from the city of Topeka, and they have since talked and don't have the concerns that they did. So I feel very comfortable moving forward with this.
Thank you. Appreciate that information. Thank you. Committee, if there's no further discussion, then you all have heard, yes, Senator Olson.
Because I think it. But the city attorney will not look at that video evidence. I would just like to amend, I can wait and do it on the floor, maybe get with Jason, but I would like to amend a piece in there, and I'd hope it'd be a friendly amendment, that the city attorney, if there's video evidence of the cop's camera or the light and the defense wants to produce it, they have to at least look at it.
Thank you, Senator. Appreciate that. And that's kind of a new topic area and awfully complicated for a conceptual amendment. So looks like if you want to bring that, that would be on the floor.
Yeah, I might pull this bill off the consent calendar.
Well,
For
if that's
that reason, to do it on the floor. I just think, if there's video evidence and it's, the state's own evidence or the city's own evidence, at least the prosecutor or the person, can.
sure. And I'm not passing judgment on whether it's a good amendment or not. And it is not on the consent calendar. The motion is not to put it on the consent
I'm
calendar.
sorry, it was last bill.
It was the last bill, yes. So,
Okay, thank you.
sure. And again, not passing judgment favorably or unfavorably for the conceptual amendment, just not going to be something in committee. So
I know it's a difficult one, and yeah, I'll do it on the floor. That's
thank
right.
you. Appreciate it. You all have heard the motion then, and if there's no further discussion, those in favor signify by saying aye. And those opposed, same sign. The motion carries. Thank you, committee. And that's going to be our work for today. And yes, Senator Baumgartner.
Thank you, Madam Chair. Would you mind speaking briefly about the meeting on Monday?
Thank you. Yes, committee, I was going to discuss that we are not meeting tomorrow, Friday, February 9th. And we currently are, as you know, scheduled to meet Monday. And as you also know, next week is our last full week of opportunity for this committee to meet and consider Senate bills before turnaround. And we do have a lot of bills in committee. And so we do have a bill scheduled for hearing on Monday, as well as possible final action on bills previously heard. So the plan, though the Senate announced its schedule after our agenda was released on yesterday, the Senate is pro forma on Monday. However, considering our workload and considering that during session, often these weeks we haven't met on a Monday and a Friday. So we've had 3-day weeks sometimes during this session. So thought it would be something that we could get together and work on Monday, February 12th. So we are currently scheduled to be meeting, and that's where we stand. But you all can check emails if anything changes, but we're scheduled to meet. So does that answer your question, Senator?
It does.
Okay.
Thank you.
Thank you. I appreciate that. Senators, any other questions or discussions? Seeing none then, thank you. And I'll say there's a big game on Sunday, which is why I think prompted the question, but we're a 10:30 committee. We do have important business in front of us and for Monday. And lastly, I'll say go Chiefs. So thank you.